Good morning, everybody. It is 11:31 on March 9th, 2021. I'd like to call the Legal and Justice Systems Committee to order, and we'll start with the land acknowledgement statement. Before we begin, we acknowledge that we are gathering on the traditional and the territory of the Lummi, Nooksack, Samish, and Semiahmoo people who have cared for and tended this land since time immemorial. Truth and acknowledgement are critical to building mutual respect for connection across all barriers of heritage and difference. We begin the effort to not acknowledge what has been buried by honoring the truth. We pay respect to their elders past and present. Please take a moment to consider the many legacies of violence, displacement, migration, and settlement that bring us together here today. And please join us in uncovering such truths at any and all public events. All right. We'll go to the next item of the agenda. And the first item there is the discussion on Senate Bill 5226, which is involving driving while license suspended thirds. So this has been a topic for the Legal and Justice Committee for quite some time. I know that Jill Bernstein reached out to me about it way back before I was even part of this committee in reference to the law advocacy group looking at a relicensing program. I know in 2005, Redmond versus Moore came out, which basically wiped away anybody that had a suspended license. And they changed the rules for the Department of Licensing. And then in 2012, they changed the law again, limiting to suspensions to only moving violations. We've invited presiding judge of the city of Ferndale, Mark Cayman, to discuss this matter so that if the task force comes together as a whole or the steering committee asks us to endorse bills or just so that we have better knowledge of how this law or how these charges actually impact the community as a whole and what us as the Legal and Justice Committee can do. Mark Cayman was a deputy prosecuting attorney in San Juan County. He was the assistant city prosecuting attorney for the city of Bellingham. He's a senior managing partner with Lustig, Cayman and Madrone in Defense Counsel, and he is currently the presiding judge for the city of Ferndale. Welcome, Mark, and thank you. I'll let you take it away.
Thank you so much, Raylene, and thank you for inviting me to speak to your group. Driving while license suspended third, it's amazing how much court resources and how much energy is devoted to what is a relatively minor charge in the pantheon of charges. I suspect that many courts, especially the small courts out in the county, are the same, would have a similar experience as Ferndale. My Friday morning arraignment calendar is predominantly driving while license suspended third. That's what I see the most of. And I think that probably most people would agree that what we're doing now in terms of driving while license suspended third cases isn't working. We're not modifying the behavior of people who choose to drive with a suspended license. What we're doing just isn't working, and we're looking for different approaches. I can't pretend to have the answer to this. I'm probably going to raise questions for people and hopefully generate some discussion. But I think every which way we turn, there are going to be consequences with the Senate bill or with other approaches that we choose to take. There are a number of approaches. Different courts take different approaches. I know that the Whatcom County prosecuting attorney has decided, well, we're just not going to prosecute standalone DWLS thirds anymore. That's certainly one way to unburden the court, to unclog the system, to be able to focus on different priorities, crimes that are more serious, that have a greater impact on the public. That's one way to do it, but that doesn't modify people's behavior. My concern is that, well, that just essentially gives a license, no pun intended, for people to drive without a license, and they continue to do it. Ferndale, we do prosecute them, but even what we're doing doesn't have much of an effect, because I see the same offenders coming back through over and over again. So whatever our approach is isn't working. And we could adopt an approach where, okay, driving while license suspended third, you're on your fifth or sixth one. That's going to be 30 days in jail. But then what are the consequences of that? Driving while license suspended third is primarily a crime of poverty. We don't see doctors and lawyers and accountants suspended in the third degree. They pay their tickets. So the criticism would be that you're locking people up essentially for being poor. It would cause problems with the jail. Going to be overwhelmed with driving while license suspended third offenders. So I'm not sure that is a viable alternative. But how do we get people to follow the rules, to drive with a valid license? And often it goes hand in hand with driving without insurance, which also has a very detrimental impact on the public. The Senate bill, as I understand it, the proposed bill that's under consideration would essentially, if you get traffic fines, you're able to file a statement that says, I can't pay those fines, and now I'm not going to be suspended anymore. Okay, well, now we're gonna have a decrease in in arraignments. It's not going to be clogging up the courts as much anymore. All right, well, we've solved one problem, but I think we've created others, because again, where is the incentive to drive validly licensed? Where is the incentive to pay your tickets? That creates a disparity in and of itself. Well, if I get a ticket, I can afford to pay it. So I'm going to be obligated to pay it. I can't file a statement that says, well, I'm too poor to pay my traffic fines and I have to pay them, but somebody else can avoid it. And I'm not sure that that's the approach that we want to take. That would have consequences too. If I were able to make the decisions and sort of enforce my will, I think one approach might be, well, we'll decriminalize it. Driving while license suspended third won't be a misdemeanor anymore. But if you get caught driving in a vehicle, the vehicle is impounded. That might be one way to disincentivize people to drive without a license. But again, that's going to have consequences too. Let's say that I'm driving the vehicle, it gets impounded. It's not my car, it's my friend's car. He loaned it to me. Well, now my friend is without a vehicle. His claim is going to be, why should I be penalized because Mark Cayman was driving without a license in my car? The impound lots will be overwhelmed. Most of these people, again, because they are poor and low income, they're not going to be able to redeem the cars out of impound. So all of these things create ripple effects. They create consequences that may or may not be desirable. And I'm not entirely sure how we provide a sufficient incentive to the public to be validly licensed and driving with insurance, and a sufficient disincentive on the criminal side that the courts can handle. I really don't know what the answer is. Raylene asked me to give you my thoughts. Those are my thoughts. I would love to hear the thoughts of others about this. I see, the sheriff is there, and this is a question that perplexes me. So I'd like to hear the thoughts of others.
My question, Judge, is do you know what the status of that bill is? It sailing through committee, or is it dead? Or
I don't think it's dead. My last information, I sent an email to AOC about 2 weeks ago asking about the status of it. And I think it was on the second reading. And I'm not 100% sure what that means to the legislature, but it looks like it is advancing. I'm not sure what the chance of passage is, but it looks like it is advancing.
So I'm aware of how it's going through the legislature right now. This was actually a pretty good bill the way it started, but it's been changed, or at least there's been some amendments recently by a senator named Cleveland down in Clark County, and she's basically gutted the bill. And I'm not sure how it's looking. I know that I'll tell you, I've reached out to Tony Golick, who's the prosecutor down there in Clark County, and asked him to talk to his senator to see if she would withdraw her motion. She's been working with the collection agencies, and somehow they've convinced her that what's going on with this Senate bill is not appropriate somehow. And anyway, Tony's going to try to talk to her and see if he can get her to change her position. But her amendment's gutting the idea, and you know, I can tell you why I think it's a good bill if you all are interested in hearing about it.
The amendment would gut it and basically leave us with the status quo. Is that?
Yep.
Arlene, and then if we can go back to Eric Ritchie for his thoughts.
I mean, I think about the why is this happening question as opposed to the law, and or which is actually addressing, you know, what can we do? To me, our culture is not very orderly. Our culture has a certain percentage of people who systematically don't want to follow rules of any kind and won't. Now, what about that? I don't know what I mean, we have a sort of free society and it encourages that. The only intervention that makes sense to me is at the educational level. It's at school early. And I don't remember a single discussion in my schooling about the rules of the road and why does it matter that we follow those rules. That was never addressed. And it's part of our society, so why wouldn't it be? So that's the only thing that comes to my mind about if this is important, then we would include it in our educational system the way that we should be having, you know, pretty big sections on politics and participating in a democratic society. So, and responsibility, where you talk about philosophic things like responsibility to your culture and to your neighbors.
I'd like to expand on that, if I may. I think you're right that what we risk is a slippery slope into lawlessness. If having a driver's license isn't important anymore and you don't need to have one, okay, we let that go. And then what comes next? What follows after that? What rules are we going to look the other way on? What are we going to say that was once important is now important? And that is my concern. There's other than the macro picture of this descent into lawlessness and barbarism that's not a society that I particularly want to live in. And I think you're right that it starts when they're young, personal responsibility and responsibility to society to follow the rules. So it's a big picture question, and I'm not sure we can answer it here, but it is something that concerns me deeply.
Thank you, Judge Cayman. I think I'm actually gonna go to Kristen Hanna. I saw that you were on the phone, Eric, and then we can come back to you if that's okay.
Sure.
You need to unmute there. Thanks,
Oh,
Kristen.
I didn't have my hand up or anything, but
Oh,
Moonwater.
sorry, it was Moonwater.
it wasn't Moonwater. Okay.
Thanks.
I mean, I would just real quick like to point out that I think that it's the money penalty. It's the nature of this particular crime that's the basic issue. I don't think it's going to cause a descent into lawlessness when we just talk about changing just the economic impact on certain class of people, but just that's.
Okay, go ahead, Moonwater. My apologies. And thank you, Kristen.
I think it's an interesting philosophical discussion to have, and interesting how those philosophical discussions sort of translate into policy and proposals as they make their way through the legislature. And so I am really curious to hear a little bit more from you, Eric. But I think one of the questions or sort of comments that was coming up for me as I was starting to listen to this conversation is about just a caution, I think, I think it's important that we not make assumptions about when we think about incentives and penalties. If we step back for a moment and think about just some basic survival when you're living in a place of poverty and needing to make a decision about whether or not you buy groceries or pay, a ticket. That those are some of the decisions that folks who are living in a state of poverty need to make. And feeding your family versus responding to a letter in the mail about a ticket, it makes a lot of sense that people are going to prioritize food and shelter and meeting those basic needs. And so, and I don't think that equates to that same individual not wanting to comply with the law by any means. So I would just offer a caution that we not conflate some of those things as we explore these and evaluate these policies together, because there are so many different intersections. And I think there's certainly probably some small group of folks in the community who just simply don't believe in citations and just flat out refuse to pay and don't want to abide by the law. But this is totally anecdotal, but I think my sense of our fellow community members is desire to comply with the law, desire to not, have something hanging over their head, and desire to take care of basic needs. And it's a confluence of those things that's so hard for people who are living in a state of poverty in particular. So if we know full well that that's the demographic of folks who generally are being cited, then let's make sure we're holding that, that perspective as we evaluate these things together.
Thank you. And I've got all kinds of hands. So this was obviously a hot topic, but I kept saying I was going to go back to Eric. So if I can go back to Eric, and then I've got Maya, and I believe Sheriff Elfo had his hand raised. So I just want to let you know I am paying attention here. Go ahead,
All right.
Richie.
Great, thank you. So I just want to start off by saying that, I really don't know what it's going to take to get people to want to be licensed, but I believe that fining people and incarcerating people creates nothing but more barriers to getting licensed than helping them. It's not. I don't think it's encouraging people to get licensed. So that's a starting point. And that's why in my office we decided that we're not going to be charging people with driving while suspended in third degree as standalone charges. And I do look at it as a crime, that's often committed by people only because they can't afford to pay or because they don't understand that they can be, get their licenses back. So that's something that I think is, fundamental in where I come from. So what I've done is I've worked on this bill. I've been working with Carl Filler and Brooke Davis from the Justice Action Network. We met with Senator Jesse Solomon, who proposed the bill. And in fact, I'll tell you that without a lot of pushing from me, I'm not sure that Jesse Solomon would have put this bill forward. He did something though that was I thought really good, and something that was something that I didn't think of. It was rather than changing how driving while suspended is either charged or defined, he changed how people are suspended in the first place. So, in the past, there were iterations of fixing the problem by making it an infraction, at least suggestions of doing that. They didn't pass. It's adding another layer, another level of driving while suspended, and that didn't make a lot of sense to me. But what Jesse Solomon did is he changed it so that people who were failing to pay in their court tickets or failing to appear in court, those people wouldn't be suspended. And basically just removing that whole category of people ended up suspended in the first place, but then added a traffic safety element to it. People who have had traffic infractions 3 or more in a year, those people would be suspended. So it's directing the whole thing at traffic safety rather than at poverty. And at that point, it makes sense. And I can support that. I think that's because driving while suspended would be directly related to traffic safety issues. We would charge it again. And I think it's just a fantastic bill. It's a fantastic effort to make this a better law for all of us. I'm not really sure how it's going. As I mentioned, Senator Cleveland down there in Clark County wrote some amendment that's gutting the whole thing. I'm hopeful that it'll turn around, but this is politics, and we just have to see how it goes.
Thank you, Eric. Maya, And then Sheriff Elfo? Maya's shaking her head.
Oh, no, thank you. Sorry. It's my Zoom volume is very poor, so I'm often like doing strange things with my head, trying to hear better. No, I appreciate Eric's comments, and I think at the heart of it, we want to consider what is the financial responsibility that we're looking for as a community. I mean, it's like having insurance seems really important, but having those the poor in our community be saddled with fines and fees that they can't pay and then can't have a license and can't work. I mean, that doesn't make a whole lot of sense. And I think that, I can appreciate a bill that's focused on traffic safety and having suspensions tied to violations rather than financial obligations that are frankly arbitrary and really oppressive to people who are on limited incomes. So that's all. Thank you.
Thank you, Maya. Sheriff Elfo?
Yeah, I think Eric covered what my concern was, just remembering that we don't lose sight of the fact that these laws are designed to promote traffic safety, and we have people killed every year in traffic collisions and seriously injured. And we have people that are habitual traffic offenders that continue to drive like that. And I think the intent to target them rather than the financial portions is very prudent.
I muted myself and then I'm unmuting myself. Thank you, everybody, for participating so far. I have a little bit of a historical background, and I have to say I swung the other way completely before COVID, just because here in Blaine, a lot of our suspensions came from Canadian drivers that came up here and got a speeding ticket and didn't pay their ticket and got stopped at the border. So the court was full of DWS thirds who were very happily able to find out they could get it amended down to a civil infraction if they paid their ticket, got relicensed, and was done with it. So we were seeing relicensings pretty quickly. And I do remember when I first started in a little bit in the court in 2005, but we were clearing out all of the cases from Redmond versus Moore. And then I saw all these people that got their licenses back get resuspended. And then again in 2012, when legislation changed it, so we were looking at traffic safety, and we changed it from you're not going to get suspended because your tabs are expired. Now you're just going to get suspended for a moving violation. So I think we're moving forward to look at the safety portion. There's still some concerns that I have when it comes to, non-payment of child support. We want people to work, but non-payment, I don't know if you can touch on that, Eric Ritchie or Judge Cayman, if that's also going to be an issue, because I know people want to work. A bigger issue I see in Whatcom County is we have so many people living in remote areas that need to get to work, that need to get to court, that need to get to probation. And I think that's where people are, I don't know how else to get there because the buses only run from this time to this time. And transportation seems to be kind of a driver for people driving around unlicensed. I do think it is more of a poverty issue, as I've seen more recently that we have repeat offenders, but we also need some type of deterrent, I think, for people to commit crimes. I'm concerned about people driving without a license and no insurance. And are we encouraging that? So those are just some concerns I'd like to touch on. And Prosecutor Ritchie or Judge Cayman?
I'd love to address that. I just wanted to say that the reason why the child support is a reason for suspension is because it's a federal law, and our state laws have to mirror that. So that is a reason for suspension. And I'd like to make that go away, but we can't. You mentioned a couple other things. Losing it now. Rats. One thing I want to I'll just mention though, this kind of an interesting side note about this. So the Department of Licensing will automatically suspend somebody for doing a number of things, and I was like, well, why don't we automatically reinstate a person's license? Why can't that be done? Well, it turns out there's a financial incentive not to. The Department of Licensing makes a ton of money, $75 a pop, from having it's a reinstatement fee, and they would lose that, and that would just kill their budgets. So that's their argument for not, making something more fair to our people. And that, it's just something that just kind of ticks me off. But anyway, I just want to throw that out there.
Thank you, Eric. I've got Chief Tanksley and Judge Cayman.
Sure, thank you. So my question, I guess, geared more to Eric, since he was in the know with the creation of the bill. With regard to the multiple traffic violations, what happens when one does not respond or appear in court even after multiple traffic violations?
Yeah, so that's a great question. Our courts are able to take care of themselves. Our courts have the ability to do a lot of things to people. They don't need a license suspension to help them coerce people to do something. They have the ability to incarcerate, they have the ability to fine, either through contempt or other ways. And it's, it seems like to me that this suspension is almost a collateral consequence, and not necessary for our courts anyway, to be able to take care of themselves. So that's, anyway, that's my position on it.
Thank you.
Thank you. Judge Cayman?
I just wanted to echo a couple of the comments. We've heard comments about necessity. Moonwater raised the point that people are put in the position of, I pay my rent or I pay my ticket. And you raised the issue of the necessity of travel. People who live in rural parts of the county, there's no public transit out there. That's a big problem. And that's, I think, one of the drivers of this is we put people in the position of having to choose between basic needs, getting to work, getting food on the table, or paying their tickets. And I'm not sure what the answer is. I think maybe this bill that's hopefully going to move forward may help alleviate some of that. And I wanted to also echo something that Mr. Ritchie said about automatic reinstatement and the financial interest that the Department of Licensing has against that. Years and years and years ago, when I was in the Army, when I was taught to train soldiers, negative reinforcement doesn't work. It doesn't modify behavior. If you want to build a soldier, you're not going to do it through negative reinforcement. You do it through positive reinforcement. And it's the same thing, I think, that we're talking about here. We can do a better job with positive reinforcement. All we have is the negative right now. I'm going to put you in jail. I'm going to fine you. I'm going to do things to you that are negative. I think that if we really wanted to modify the behavior of people who are driving around without licenses, we can do a better job of positively reinforcing them. If you do these things, your license is going to get automatically reinstated. You don't have to jump through a bunch of hoops, which, by the way, right now are almost impossible for people with the COVID closures. I hear it in court all the time that I'm trying to get my license, but I can't get through to the Department of Licensing. I'm trying to get my license, but I can't get an appointment. And I think Mr. Ritchie raises a good point that perhaps some of the approach that we take in the current Senate bill and maybe in the future would be geared toward more of that positive reinforcement to try and get people to change what they're doing, hopefully.
I think, if I may, one approach is to provide like an amnesty day where people can come in and set up payment plans and not have to put down a certain amount of money, or, there are different approaches that I've seen other courts take. And even with I don't know the intricacies of Washington child support. I don't at all, but I know that when I practiced in Ohio, they would have child support suspension amnesty days where people could come in and re-engage in a payment plan and get that suspension removed immediately so that they could work and start actually paying on the payment plans that they just re-established, when they were in different circumstances. So I think there are creative things that could be like the carrot that Mark's talking about, like, hey, come on in, let's reassess this, and having a judge being able to even, strike some portion that seems unreasonable under you know, if someone's got like a decades long of suspension issues, which people do, you know, that I like those. I love those ideas, and certainly my office would help with those.
Thank you, Maya. I know one of the things that I read and something that you said is the courts take care of themselves. And in retrospect to the comments, yes, the courts take care of themselves. There was some concerns just because I know a lot of us are small courts. There's not a lot of us here. I look at the bill, I see, okay, now if somebody can't afford their ticket, they're going to send proof in, and then who's going to be screening that to see, is that just going to be the one-person court or the two-person court? Are they now going to be screening individuals to see if they can actually afford to pay that speeding ticket? We do offer some, I mean, and I can't speak for every small court, but I know a lot of us do go out there and we work with people. I've seen the judges pull things from collections, offer community service. We're offering people to do community service outside of Blaine if they live in different jurisdictions. And I think there's a lot of frustrations with fellow clerks that have answered the phone call to the same person a day before their payments due. I need more time. I need another week. And we understand. We've all lived paycheck from paycheck, or like most of us have it at some point, that we know the struggles and we care, but people don't respond. They ignore it. And then you get frustrated because you're getting the same people over and over. You pull it from collections, you give them the chance, you give them the community service, and they still ignore it. And then what are the consequences there? And so I think we need to have positive reinforcement, but I also think there's a concern that there's not always consequences. And if people can not have to pay a speeding ticket and know they can't by sending something to a court that might not be adequately staffed to review everything, and then people are getting away with not having a license and not having to pay things. So there's definitely some concerns I have. I'm not against it. I just want to point out some things that I had questions on. Any other comments? Feedback? I'm seeing none. All right. Thank you, Judge Cayman. You're more than welcome to stick around for the next topic. If you'd like to, you're free to leave. I don't want you to feel like you're obligated. The next.
Thank you so much for inviting me. I appreciate
the
opportunity.
Thank you, Judge Cayman. Appreciate it. The next topic on our agenda is the Supreme Court ruling on State versus Blake. I've heard a lot of squabble. I've heard different law enforcement officers concerned about their jobs and what they're doing and what they can't do and how this is impacting us. Blaine does have a possession of a controlled substance, so I've been busy dismissing warrants and pulling cases and running reports 10 years back to see what we have. So I know it's impacting me. I'm sure it's impacting the county Superior Court and prosecutor's office, having lots of fun. I would like to hear from Sheriff Elfo and Prosecutor Ritchie also on this topic. One from Prosecutor Ritchie on how this is going to impact the LEAD program that we've got going, that I think is so positive, and I'm worried this is going to be a detrimental. And Sheriff Elfo on impacts and thoughts and concerns.
Raylene, my apologies for interrupting, but since this is being recorded, just for the sake of any person who might watch this later, could, before either of you speak, or could one of you, maybe Eric, just provide a brief synopsis of what this is, just to make sure that people understand what the legislation is and how that's going to actually impact before you talk about the specifics of local impact. What it means.
Do that.
And Eric, could you also talk about the impacts to drug court as you see them? Thank you.
Yep. Yeah. So just I guess as a preliminary matter, this is not a legislative issue. This was a Supreme Court decision. And what happened was that the Supreme Court found that the possession of a controlled substance, basically it's called simple possession as we all use it. It's unconstitutional. And so the impact is great. It goes back, to the origin of the statute, saying that everything that we did with the charges it was unconstitutional. We shouldn't have done it, and so we're trying to fix all those situations. It's going to have a huge impact on law enforcement. I have a lot of things to say, but let's let Bill Elfo talk about the impacts on law enforcement before I get into some of the impacts that we're having in our prosecutor's office.
Yeah, I could speak briefly on the Blake decision, which ruled, or where the Supreme Court of our state has decided that the possession of controlled substance statutes are unconstitutional. This isn't a legalization or decriminalization that we see the legislatures or citizens initiatives do in Oregon, where they set quantity limits. They prohibited children from having possession of drugs. This is, we're in a wide open situation. And quantity alone does not infer delivery or manufacture. So we got people in possession of relatively large amounts of narcotics and not be able to take enforcement action. And we could have children in that situation too. And children can't possess marijuana because there's a separate statute, but we could have children in possession of fentanyl, methamphetamine, heroin. And I think that's very problematic. I think there's merit for trying to move philosophically from moving drug addiction from criminal justice arena to public health, but you have to provide what the treatment options are and the alternatives. And I could just tell you, for our people out on the street that see it day and day, we find not everybody is eager to go to drug treatment. Not everybody wants to go, and it takes some triggering act. And we've come across people that are literally circling the drain. They're living in circumstances where we know we're going to be there in a day or a week or maybe even a month away, and they're going to overdose and they're going to die. And getting them into the jail, getting them medical attention, and trying to induce them into some type of treatment as a last resort has been effective in some cases, and some lives will be saved as a result. So I'm very concerned about the consequences. This is what happens when the legislature doesn't act and we get a court decision with such wide-reaching ramifications.
Thank you, Sheriff Elfo. Stephen Gockley?
Just to loop back on Moonwater's background emphasis, I want to say that in reading the decision, it does throw a lot into chaos. I can appreciate the workload that Eric and Raylene are facing right now, but I think the background information is that Washington was the only state in the country that did not require that you had to know you were violating the law to be guilty of simple possession. That's all. You can still be charged with simple possession. It's just that in the trial of Blake, she said this wasn't hers. It was a new pair of jeans. She didn't even know she had it. And the court did not even have to entertain that issue. Now they would. So that's that doesn't throw wide open possession of drugs, or it won't as soon as the legislature responds to it, I think. Okay. Eric disagrees, and I'm interested in his perspective. So and Maya may also, but that was my reading, that we were a real outlier, and the legislature had insisted that we were an outlier in a way that goes against centuries of Anglo law. So that this was a correction of that. The court itself divided on how it should have taken care of that. But this is a fixable problem, it seems to me, in the bigger picture. Eric.
So yeah, thanks. I agree a lot of what with a lot of what Stephen just said, and that is that the state of Washington was a huge outlier, And I mean, he's absolutely right. And that's why the law, was found unconstitutional. But this is far reaching. This is hugely reaching. It's not just about, the cases that didn't have knowledge, that we couldn't show knowledge. This is impacting every single case. The entire statute's been thrown out. And that means, every single case that we've prosecuted in the last 50 years with this should be vacated. We should be talking about, paying back LFOs, and I'm going to get to that in a minute, paying back forfeitures. I mean, it's far reaching as you can imagine. Yes, the legislature can fix it, but the political will is not there. I mean, I know that they could easily fix it by adding a knowledge element, but they won't do that. They're going to be looking at doing other things, probably similar to what Oregon did. I think that's what our legislature would really like to do. And now they have the opportunity to do that, and that's what they will do. They probably are not going to do anything this session. And right now, it's sounding like we're going to be without a law for a period of time. And as Bill talked about, it's legal for kids to have heroin, methamphetamine, and fentanyl. And that's a real problem. That's a real concern for all of us as a public health issue. Whether or not this possession of controlled substance be a criminal issue or a public health issue, that's up for debate. But right now, I mean, without any control, I think it's very dangerous. And I think, as Bill described, it's a real problem. Now, as far reaching as this is, costs. WAPA has looked at this, and we figure that the costs are about $100 million. That's right, $100 million statewide. And what I'm talking about is court costs to vacate, court costs to resentence. There's gonna be a lot of resentencing involved. And of course, the return of LFOs and forfeitures and things like that. Our estimate is $100 million. That's gonna fall on the county, on every county. And we're all gonna have to pay our portion. It's gonna be a large amount. It's also going to fall on the cities. As Raylene mentioned, the city has been working, the city of Blaine has had their own controlled substance charge. And because of that, they're under the same, they're on the same hook that the county's on, paying people back. And it's really complicated. It's complicated who gets it, how they get it, who's gonna be presenting that to them. Should a person have to come before our courts to get it back first? We don't know. Is this something that we're going to have to be directly sending to folks who've been convicted of these crimes? We don't know. We're still working on these issues, and it's a real complicated thing. So there has been some talk about whether or not the cities can just go ahead and make their own charges, ordinances, currently. And the answer to that is no. I mean, as recently as today, I saw an article in Como News saying, hey, the cities can go out and make their own controlled substance act if they want to. Well, they can't. There's a state preemption that prevents them from doing that. I think it's a real mistake that Como and some legislators talked about, because the cities, if they went and did that, they'd have the same problems that Raylene's talking about currently having to pay people back. So let's talk about some more impacts on treatment. Someone asked, I think it's Jackie asked, how's this impacting drug court? Yeah, well, it is. People are not going to be able to get treated as readily as they once did without having charges. As Bill talked about, sometimes people need to have some coercion, and sometimes it's a crime that coerces people to get treatment that they often need, which ends up protecting our community. And we lost 6 people from our drug court. 6 people from what was already a historic low in drug court due to COVID. And, that's a real issue. Lead, how's this impacting lead? Well, right now, I don't see it impacting lead at all. That's one thing that we have working for us. Lead is something that's voluntary. It's not a direct diversion program at this point. So we haven't had to directly divert anybody, coerce anybody into getting into the program. They've all been joining voluntarily. So it's not going to impact lead. It has not impacted our funding that we've heard about. So I think we're okay with lead, but this is a far-reaching bill. It's a costly bill, It's a far-reaching decision. It's a costly decision. And I think it's a dangerous decision as it's leaving people currently unsafe in our community.
So I just might add to that I know those 6 people in drug court were on what we call criminal justice treatment account funds to pay for some of their treatment services and their housing, rental assistance, that kind of thing. And so I think the state's going to allow us to keep them on, even though programmatically they're no longer eligible because they're no longer in drug court per se. So hopefully we'll be able to work that out. But that also could be a big problem.
After you, Sheriff.
Sorry about that. I had to take a quick break. Any comments, any questions? Moonwater, go ahead.
I didn't know if Sheriff Elfo had something to say first. I was gonna just piggyback off something Jackie just said. Okay. All right.
Go ahead.
Okay. I think just the question, so many, a couple things. One is just for the layperson who, I don't know how many people listen to the recordings after these sessions. I don't know how widely, but for the layperson, for historical record, if someone could just simply summarize what this decision was, that would be really helpful, I think, for the record of this meeting. And then the other question that's coming up for me is just, and this is sort of jumping way ahead, but so curious about drug court, is what would it look like for our community to offer those same services voluntarily and to have them be funded? And what an amazing opportunity if we could get an exception to use those criminal justice funds to continue supporting people in the program. What a great foundation that lays to make an argument to fund the services for people to participate voluntarily outside the court system or some component of the services that are offered through the drug court program to people who want to opt in and receive that, even if it's no longer part of their criminal experience, if that makes sense. So food for thought, but that summary would be super helpful. I think I'm understanding myself, but that would be really helpful to hear.
I can read a summary if you would like. Okay. The state prosecuted Ms. Blake for unlawful possession of methamphetamine following her arrest and jail booking on another matter. At booking, a jail officer found a small amount of methamphetamine in the coin pocket of Ms. Blake's jeans. At her bench trial, Ms. Blake asserted the defense of unwitting possession. She testified that a friend bought the jeans secondhand and gave them to her 2 days before her arrest. Ms. Blake also testified she had never used methamphetamine, did not know there were drugs in the pocket. Ms. Blake's boyfriend testified Ms. Blake did not use drugs and she received the pants from a friend. The court convicted. They held that strict liability drug possession statute exceeds the state's police power by imposing harsh felony consequences on innocent non-conduct with no mens rea. Passive and innocent non-conduct falls outside the state's power to criminalize. So does the strict liability drug possession statute with these substantial penalties for such innocent passive conduct exceed the legislature's police power? The due process clauses of the state and federal constitutions, along with controlling decisions of this court and the United States Supreme Court, compel us to conclude that the answer is yes, this exceeds the state's police power. The statute criminalizes innocent passive possession, even by a defendant who does not know and has no reason to know that drugs lay within something they possess. The legislature's police power goes far, but not that far. The portion of the simple drug possession statute creating this crime violates due process clauses of the state and federal constitutions and is void. We vacate Blake's conviction. So all possessions under this statute are void.
You're saying that statute was created 50 years ago. So it's an exercise now of going back 50 years to look at every single case that.
Right. And so then our sentencing schemes in Washington rely on the calculation of offender scores, which consider prior convictions to include prior possessions. So people who have been sentenced on a totally unrelated crime have been affected. If they have prior convictions for possessions, their penalty for, say, possession of a stolen motor vehicle has been enhanced by this unconstitutional conviction, their sentencing has to be recalculated. They will serve less time if there are offenses that are removed from their offender score. So people, many, many, many people who are in state custody now will need recalculation of their sentences.
So there's the direct impact and then the indirect impact if that was in. So that's very helpful. Thank you so much for that summary. Okay.
Sheriff Alpha, did you have more to add?
No, I got called by the media on this. And one of the questions they had was interesting. How many people are in jail currently? This is the date the decision came out last week on simple drug possession charges only. And that date it was 0. There were none. So it didn't affect anybody in our jail population that was housed there on that alone. But that's probably reflects recent practices towards incarceration reduction and
I can,
COVID
sorry to,
policies as well.
yes, and thank you, Sheriff. And in addition to that, I got in, there were only 3 individuals in prison exclusively on possession charges. And I am expecting to hear from Eric Sigmar that all of those have been dismissed by the end of the day today. I was asking him about those individuals yesterday. They should not be incarcerated any longer. So I expect that paperwork hopefully is getting done today. But there are many people who are incarcerated on mixed convictions, and that's more complicated. They may be entitled to release because their sentences are reduced by the elimination of the possession charges, but it's kind of triage right now. Like, who are the very, these 3, for instance, are very obvious. They need to be released. They shouldn't be in custody. Parsing through the thousands of remaining people is, we're all struggling with how to receive the data that we need to find the people, and then who is going to do the work of resentencing, and where is that going to happen? Will it be on Zoom? Will it be with local counsel? Is there going to be a statewide appointment of counsel to deal with this at the institutions? It's very chaotic right now. And as you can imagine, anyone who's in custody who believes that their sentence should be recalculated would like that done yesterday. And so our office is pushing on the prosecutors who are in control of filing the dismissals, but who are really inundated at the moment. And they're trying to prioritize with their staffing limitations as well. So it's rather intense.
Any other questions or comments?
Maya's right.
I concur. Stephen.
I don't know, it may not be appropriate to say this, but I just think this and the bill on DWS 3 that we were talking about demonstrate very clearly the validity of the community members who critique a systemic system that is so off kilter. You can see how a bad legal approach, a singular legal approach in the United States has just rippled out, so the consequences are overwhelming to try to correct it. You can see in the Senate legislation how the collection agency industry can intervene to protect their own financial interests, which were interjected in the system because the courts were not adequately staffed to make individualized payment decisions to accommodate poverty situations. How they now control the legislative process. And so when people talk about the need for systemic correction in the criminal legal system, this is the kind of stuff they're talking about. And
We are overjoyed to have this work to do. I don't mean to say that the intensity of it in any way it was public defender Christmas, honestly, when the Blake decision came out. I mean, we are thrilled with the decision. We think it's the right decision, and the consequences are enormous, but it's the right decision. Thank you.
I'm going to have to sign off. We've got a kind of an emergency with one of our people here who took a medical issue. So.
Thank you, Sheriff Alpha.
Eric and Maya, do you think it would have made any difference in the ramifications of this if Justice Stevens' opinion, which was basically to deal with it as a statutory interpretation matter and just interject a mens rea requirement, overruling the prior cases, would that have made any difference? And
I mean, it would have made a difference, but how that would just, their stare decisis, it's a fundamentally flawed statute, I think. And I don't think they can retrospectively, like ex post facto, insert this mental state that did not exist and that case law for decades said did not exist. So that would be fundamentally unfair and wrong, in my opinion.
Moonwater?
I was just thinking over time, because clearly the system, those of you here in this room who are responsible for addressing this are going to have enormous work ahead of you relative to this particular group and the task force. While I'm hearing that there wasn't anyone in the jail directly that should be sent home immediately, I am curious, just to build off what you were explaining, Maya, about the kind of stacked consequences or impact of people's criminal history and how there's sort of an untangling of that. I am curious, is there anyone who might be in the jail now with multiple charges where if this one is vacated, it would reduce their jail time or impact that? And so I think this committee and the task force as a whole would probably have an interest in understanding that nexus over time.
So I just wanted to add a little bit to that. Maya's right. I mean, and there are people in the jail that have multiple charges that are impacted by this particular charge. If it's dismissed, they would be released, or at least they would have a lower sentence. And it's complicated to figure out exactly what that is. We're going to need people to either bring it to us, or we're going to have a much better system, a case management system to put together to figure it all out. Just picking through everyone's file and trying to figure it out. I mean, it's just daunting. What a daunting idea that would be. So Moonwater, we've already dismissed 200 cases. 200 cases have been dismissed, and that's significant. It's and that number is growing every day. Those are cases that were filed, maybe pending, maybe out on warrant status. It kind of runs the gamut. There are just a lot of cases. And we're trying to take care of the ones that are the lowest hanging fruit first, because it's important. They're the ones that are going to be the most impactful. And then after that, we're going to be moving toward the other cases like Maya's talking about, like you just asked about, people who are kind of tangled up in other matters that should be released or have lowered sentences. But anyway, it is a daunting practice, but we're trying to do it. We're not fighting it. We're trying to do it as quick as we can.
Stephen, your hand's up, and Arlene's hand's up.
This decision came out a day and a half before the steering committee met last week and formulated the agenda for the task force meeting next Monday. I'm wondering if Eric and Maya think this would be worthy for us to try at the last minute to put on the agenda for Monday's task force meeting as a whole, just because of the the impact that this has throughout the whole system. Not that we'll know a whole lot more about where this goes, but we will understand how much scrambling is going on, how deep and how wide the impact is, and the potential effect it has on incarceration. Would that be something maybe you two would be prepared to speak to during the task force meeting Monday morning?
Yeah, I can be available. I have a court obligation that starts. I would probably need to leave no later than 9:45.
Okay, I will talk to Jack and Jill Nixon and see if we can get it on the front end of the agenda for just a report and a bit of discussion, because I think the information both of you have imparted here would be relevant and of interest to everybody on the task force. Thank you.
Arlene?
I'm thinking of two important things. One is our yearly report and finding a way to insert this event into that report and connect it to the other things that we're doing. And the other piece that we've been talking about so much lately is external communication. How we're going to include these changes, these potential changes, to communicate to the public, because, you know, I doubt if the public fully understands, what's going on here. And we're called incarceration prevention. That's why we're here. And all these bits and pieces that have been happening, which are really monumental, but in pieces, are together. The sum of it is the prevention that is being created. And it seems to me pretty large what's going on. And I don't really think that the public knows the extent to which changes have occurred. So I'm really big on the issue of the external communication. I'm really pushing that, because what's the point of, well, I mean, we're doing this because it's the right thing to do, but people have to know what is going on in their government, and they need to understand it, and so on. So
I'd like to comment on that real quickly. The people don't understand what's happened here. They don't get it at all. I talked to Denver Pratt from the Herald on Friday, and I said, "Hey, how come you're not writing something about this?" And she goes, "Writing about what?" You know, she didn't understand it. She's involved in the newspaper. She's read the article that was put out, I think in the Tacoma paper, and was reprinted in the Herald. So anyway, we talked about it a little bit, and she goes, "Oh, this is kind of interesting." And then her editor said, "Yeah, you got to get this done by Saturday. We got to put it in Saturday's paper." And next thing I know, she's interviewing me, and we're talking about it. And then she put something in the Saturday paper, and guess how many people commented on it? Yeah, either nobody's paying attention, nobody gets it, nobody cares. One of those things, I don't know. It's
well,
kind
it's
of
like,
mind-blowing.
Eric, it's like advertising. Communication, you have to repeat your communications many times, right? In order for the message to get through and to be fully understood. So this is sort of a government entity. So it's, it's not run like advertising business, but we need a branch, we have to have, we have to get the message through. Otherwise, we're just, we're doing things. But this is very, I just think tremendous changes have occurred, and I'm thrilled about it. And I would like to see our community appreciate the work that's been done.
I'm curious about what is happening and I don't know, in Oregon in response to their decriminalization, and sort of how as a community they're choosing to address substance use disorder in the alternative of criminalizing it. So I don't know. And if our legislature is considering looking to the South and maybe using that as a model, maybe that's what's going to happen. Maybe they're not going to insert an intent into and recreate or try to recreate the old system. Maybe they're looking to create an alternative. And I don't entirely know what that looks like. I mean, maybe it's using grace and lead and, you know, fully funding those options for intensive case management as alternatives to criminalizing substance use. I don't know.
Well, that's why I'm here. I've been on this issue for a long time, because it was when I worked in crisis triage that I saw what was missing. And it just makes sense to go to the heart of things as opposed to we working around the edges. The heart of things is that our community needs care and treatment and special services to be fully filled out. It's been touched on today in our conversation, but I guess I want to beat it to death because I know that this will do so much for our community's problems, whatever social problems we have. It won't be perfect, but it will be closer to a better system, a less punitive and a more positive system. This is something that we can do. We've got to get the money moved into place, and it's starting to happen. So, you know, all we need to do is in our positions of power to nudge, you know, and that is what you all are doing, which I just thank you so much.
Thank you, Arlene. I think as a committee, something that we want to be able to track and look at from this point on, from when the law changed, is statistics on treatment. Is the amount of treatment providers that are out there, are their numbers going to go down? Are they going to go up after this? Are people not going to go to treatment because they're not required to? So are the treatment providers going to be used more? Are we going to see increase in unemployment? There's going to be a lot of other factors. I mean, COVID's already a huge factor, so it's kind of hard to differentiate, but if we can see what those numbers are after this decision was made. Mental health, are we going to see more people with mental health? Are we going to see more reckless endangerment charges of children? I think those are all factors we want to look at. And as a committee as a whole, I think we need to look at what other statistics and numbers do we want to be able to track to see what the changes are. Question out there for maybe Judge Freeman, Maya Vanya, or Eric Ritchie on the sentencing guidelines. I know that Sheriff Elfo pointed out that there was nobody in jail currently. Definitely different for the prison population. And I'm not as well versed when it comes to sentencing guidelines and how the different impacts are made. But are we looking at primarily felony convictions that are going to be overturned in prisons, that are people going to be released? And is it going to be impacting the local jails as much as it is the prisons? Or how does that all work? And sorry, I've just given you guys a whole lot of information at once. Anybody?
I mean, the sentencing, it won't affect, I mean, misdemeanors, you don't look at criminal history to sentence. So it's not going to affect district and municipal courts in the same way that it will affect felony superior court, because for each felony, there is a sentencing guideline that's you determine where the person scores based on their criminal history. So it affects many people who are charged with felony offenses. Like if I have someone in custody right now, for instance, who had 3 pending cases, one of which was a possession, and we were looking to negotiate that. Well, when you remove one of the cases, then we're now just left with 2 to negotiate, and that's a whole different posture. But for resolved cases, it is incredibly complex because negotiations have taken place. People pled maybe to a possession charge in place of a different offense in a plea negotiation. Maybe something was dismissed. Maybe something wasn't charged. maybe there was an unfiled event. Each case is literally unique as to the circumstances of that person and what went into the negotiations and what the outcome was. And I mean, anyone who had a possession charge is touched by this. And I would imagine that's nearly everyone who is incarcerated.
Judge Freeman?
I'll just add one more impact that I don't think has been talked about yet, and that's the sentencing alternatives. And how many people do we have on DOSAs, and both in the community and prison-based DOSAs that now, based on recalculations, are going to impact either how they're successfully or unsuccessfully completing those terms. So that's going to be a huge impact, because a lot of those DOSAs that I see many times will have possessions in their criminal history.
And for instance, one of the 3 people who are incarcerated only on possession offenses is someone that I represented with a residential DOSA who was revoked off of their alternative and went to prison to serve a sentence because they didn't comply with a treatment alternative. Well, that person needs to be released because they're held only on a possession charge. So like all those people in community custody on supervision by the Department of Corrections should no longer be being supervised, required to do anything.
Yeah, so I'm just going to pile on that a little bit. Yeah, Judge Freeman's right. Rescoring people in the DOSAs is going to kick people out of the program. It's going to mean that they don't get the treatment that they were signed up for, and that's that is unfortunate. You're talking about jails versus prisons and who's going to be impacted more. That's hard to say. Both will be impacted once we untangle all the crimes, because you can end up in jail just as easily as prison based on having a VUXA conviction to tangle in with another charge. So it's going to be both jails and prisons are impacted. District court and cities are going to be impacted too, because we've reduced a lot of charges down to district court. That was a plan of ours. We move things down that way. Direct filing. We've done other reductions along the way, and those convictions are no longer valid because the statute's unconstitutional, and the city's going to have the same issue. It's a real complicated mess that we're going to have to work through.
It would be so interesting. I know this is very low on the level of things that you'll need to talk with people about as you all start to navigate through the untangling of this. But how fascinating would it be to ask all of these folks who are impacted on the cusp of being released if they had an interest in continuing with treatment if it were voluntary, if the resources were made available. Would they still opt in? And how powerful would that be for our community to understand that voluntary interest and the scope of the desire there and need?
So that's a great idea. I like it quite a bit. Some of the people that are currently in services won't be able to be in services anymore after this. I mean, we heard Jackie mention that some people might be able to retain their housing. They might not. People have been kicked out of drug court because they're no longer qualified. Of course, the res doses will be in prison-based doses, the same thing. But Maya, why don't you tell us whether you think people will want to do drug court voluntarily?
Well, it wouldn't be drug court, right? But other people want to go to inpatient treatment. I mean, I think there, I don't know. I mean, people have a window of time when they want treatment. And if you don't make it available in that window of time, they no longer want it. And, having our community literally say to the people that are being released from prison, you want to walk right into a treatment facility that will link you with housing so that you're not homeless in a day when we release you from prison with nothing. But some people would be interested in that. Would all of them? Maybe not. But would some large number? Yeah, I would think so. I mean, people are going to be released spontaneously, unexpectedly, with no resources. So it's just the human response is sure. But it's anecdotally responding. I don't know. I mean, that's based on what I see in the human nature.
We have waiting lists for most treatment programs. If you have a waiting list, that automatically gets rid of a lot of people because of the timing of it. There should be no waiting list for any treatment whatsoever. There should be empty beds, excuse me. That's my opinion about how it works.
So I'll agree with Arlene and Maya that timing is really important, but I also wanted to point out the problems with drug court and people wanting to do that voluntarily. Drug court's hard. Drug court is a long, hard slog for people, and they wouldn't choose to do that if they weren't, coerced to do it by charges. I mean, that's something that I just happen to know. People struggle with it because it's so hard. They would prefer to do other things, and we've been giving them other alternatives, and they've been choosing those other alternatives. It's I think it's a great program. It's very effective at helping people, but because one of the things that makes it effective is all the hard work that gets put into it. So, I'm gonna differ with Maya a little bit. I think that if given the choice, people would choose not to do drug court.
I think that drug court that is intended to serve a high risk, high need population who are, where there is a concrete benefit to someone who's maybe charged with a more serious offense, where they're meeting that criteria of high risk, high need, which our drug court isn't designed in that fashion, that it would be a very appealing alternative. But that's not what we do. We allow low risk offenders into the program, like people who are just have possessions. And it is, if someone has no criminal history and they want to get the benefit of retaining a clean record, as a defense attorney, you can explain that, look, if you jump through these hoops and go through this program and remain crime-free, you can keep your record clean and not have a conviction. So there's this population of people who aren't really high risk, high need, but who have one case and they do drug court. And so now those people are no longer eligible. I still think there's a mission for drug court. I still think there is a population that would benefit from drug court. But we have to kind of redefine that population and our commitment to helping and investing in the high risk, high need population that drug courts should be designed to serve.
I think we've gone off a little bit, but I'm going to have to add to that. High risk, high need talks about people who are difficult to serve because of their addiction issues. It's not about the kinds of crimes that they've committed. So that's a different thing. And our drug court is broader, allowing more people, more types of crimes than virtually any other drug court in the state. So we are admitting people and allowing people to do it who have more than simple possession cases. We have, just a wide variety of cases in our drug court. And that's why we only lost 6. We didn't lose, 28, and I'll tell you that I do know that other drug courts in our state have virtually lost everybody in it.
Yeah, but I think we only had like 28 in our drug court.
I know, that's why I use that number.
Well, I just wanted to add that as somebody who started in behavioral health in the SUD treatment addiction field, that some people actually do better with a little bit of extrinsic motivation. And sometimes as an SUD counselor, we worked really well hand in hand with probation officers, especially here in this community, to try to make sure that people had all the right things they needed. And sometimes that meant some extrinsic motivation because they don't have enough, their disease process has been such that they don't have enough internal motivation to carry them through into recovery. So they really need an extended period of time where they have something else guiding them to stay in treatment. My most successful people in treatment were those who came into treatment and had some sort of something happen, whether it be a boss that said, you need to go to treatment or you can't work here anymore, or a wife who said, oh, I'm going to divorce you if you don't quit drinking, or probation for whatever reason. So I just know that experience tells me that some people really, really need that. A lot of people actually. And there's lots of evidence, research from the past that the state used to do, showing that enforced treatment actually works just as good, in fact, many ways better than voluntary treatment. Because a lot of people who come in and volunteered for treatment were just saying they were there for themselves, but they weren't really. So I just wanted to make that point because I think the brain needs time to recover and for people to begin to own and engage in their own treatment. Sometimes those external motivators help a lot.
Thank you, Jackie. I want to make sure that Moonwater gets a second to talk, and then I do want to move on to at least number 4 because on our agenda, and I know that this is going to be a topic that's going to be at the next task force meeting as well. So Moonwater, if you can go quick, we can move into section 4, and then we're going to have to wrap it up because we're running out of time. It's a hot topic.
Great, hot topic. So planting a seed for a future conversation. What's coming up for me, and this is broader beyond drug court or drug treatment per se, is just community safety net and a broader definition of reentry. So what might our responsibility be as a community to the various individuals who are going to be ushered out of the system and the sort of unintended social consequences of that? If they have been linked to resources in our system that have been helpful, and now as a result of being ushered out of the system, they're going to be cut off from those resources. Is there an beyond the people in this committee, but an overarching need that's going to be coming down the pike that we need to address as a community in terms of intentionally connecting people to resources that they're no longer going to have access to? So I'll pose that question, whether it's this committee or some other committee. That question's now in my mind. I wanted to get that out there.
Thank you, Moonwater. I appreciate that. Number 4 is coming fast. And so the next meeting, we're going to definitely really have to delve into this because we've kind of ran out of time to hit a lot on it. But we have to discuss the content to be included in the committee report for the Incarceration Prevention Reduction Task Force annual report. And I've never done this before, and Arlene's never done this before. I don't think this is our first time as co-chair with this, and I've been advised that Mark Gardner's not going to be helping us out with this. So I'm going to be relying heavily on Stephen Gockley and Jill Nixon to make sure we're doing this, but I need help from the committee, and I need you guys to help us comprise of, in the past, we've done introduction, goals, progress, issues and opportunity, and next steps, graphics, call out information. So if anybody has any feedback on that right now, please bring that forward. Otherwise, make sure you're ready for it next month, and please give me feedback on all of these for our annual report.
Did you mention reentry? I didn't.
Reentry would be something that would be part of goals or progress. We need to look at what we've done in the past, and we have to present our annual report from what we did last year, what we're going this year. And so definitely reentry is going to be a part of that because it's been a topic that we've discussed, and these new impacts on the legislative action and constitutional rulings, Supreme Court rulings that definitely impact our future and our goals and next steps. But what other items do we think as a committee we need to make sure we're bringing forward?
I mean, to me, the goals and the accomplishments are the two most important things. What have we done in this period of time, and what are we hoping to do? So if people would start thinking about that, or if you have ideas right now, that would be great. We've really talked about so many topics.
I just want to say one more thing about, am I on? About reentry. And I'm just thinking about, Arlene talked earlier about our purpose, our very title, Incarceration Prevention and Reduction Task Force. And I think we've been thinking about reentry as such a separate topic and not really thinking about it enough as it's a built-in issue, because if we're successful in reducing and preventing incarceration, by definition, our success includes reentry. It's a reality. It's not just sort of this separate thing. It's happening now. I mean, the Supreme Court has forced the issue upon us. And I just would be remiss as a person, as a proxy to the consumer representative here, not to bring that up and not to just really paint that as a big reality. It's landed here. It's not like, wow, you know, that's our goal in the future. It's here, whether we asked for it or not. It's forced upon us. And I think it should take center stage, not just sort of a separate topic. So yeah, just wanted to speak up there. Thanks.
Thank you, Kristen. Stephen?
I was going to say this to Raylene and Arlene separately, just thinking about the new year for the committee, but I think it's relevant in thinking about the annual report as well. I think the past year, for a number of reasons, this committee has done a really good job of bringing in speakers who've provided excellent information across a spectrum of issues, has laid a base of common understanding amongst committee members. What I don't think we've done, and I think what we ought to concentrate on this year, and it would be directly relevant to the report, is to think about how to take that understanding and that information and convert it into actual action item recommendations that this committee could make to the task force, which in turn could make to the county council. I think we've been a little bit short on the action recommendations. And I think that's where we could concentrate this year. We could concentrate in the goals that we would report in the annual report as well. So I think the base has been laid. I think it's been laid very strongly. And I think now it's time to turn this into something concrete. They won't be all encompassing. You'll have to pick and choose out of the different areas that we've heard speakers on. But I think now is the time really to take that challenge up.
Thank you, Stephen. Any other feedback on it at this time? We are at 12:59. We're going to sidebar items 5 and 6 for our next committee meeting. And we're going to look at other business and public comment. Is there any other business? Hearing none. Do we have any public comment? Jill, are you able to assist?
Yes, we have one attendee at today's meeting. If you would like to speak to the committee, please virtually raise your hand now. And no hands are raised.
Thank you. Well, that was a very actively participated meeting. I want to thank everybody, and I'm going to call this meeting to adjourn at 1 o'clock on March 9th. And just ask everybody to come with your thinking caps and input for the task force report for our next meeting. And I'm sure we'll revisit some of the stuff at the task force meeting on Monday. Thanks again and have a great day.